Every year, ordinary people lose billions of dollars to investment fraud, not because they were careless, but because they did not know the rules that are supposed to protect them. Today, we are going to fix that. Welcome back. In this video, you are going to learn exactly how securities regulation works in the United States, why it exists, what the government requires from companies, and how these laws protect you as an investor. Whether you are studying for a business law class or just want to understand how Wall Street is actually supposed to operate, this video is for you. Let's get into it. Section 1. Why securities regulation exists. Imagine it is 1929. The stock market has just collapsed. Millions of Americans have lost their savings overnight. Investigations reveal that companies had been selling stocks to the public while hiding crucial financial information. Investors had no way of knowing what they were actually buying. The damage was catastrophic. Congress responded by passing two landmark laws: the Securities Act of 1933 and the Securities Exchange Act of 1934. These laws created the foundation of modern securities regulation in America. The core idea is simple. If you want to sell investments to the public, you have to tell the truth, the whole truth, and nothing but the truth about your business. The government is not picking winners and losers. It is making sure everyone plays with the same information. The Securities and Exchange Commission, or SEC, was created by that 1934 Act, and it is still the primary federal agency overseeing securities markets today. Think of the SEC as the referee of the investment world. Its job is to enforce disclosure rules and go after fraud. But here is the question this raises. What exactly counts as a security in the first place? Because not everything labeled an investment actually falls under these rules. That answer might surprise you. Section 2. What is a security? You might assume stocks and bonds are securities, and you would be right. But the legal definition goes much further than that. The Supreme Court established what is called the Howey test back in 1946, and courts still use it today to decide whether something qualifies as a security. Under the Howey test, something is a security if it involves an investment of money in a common enterprise with an expectation of profits coming primarily from the efforts of others. Let that sink in for a moment. That definition is broad by design. It means that limited partnerships, certain real estate arrangements, and yes, even some cryptocurrencies could be considered securities, depending on how they are structured. This is why you hear so much debate about crypto regulation. Whether a digital token meets the Howey test determines whether the SEC has authority over it. When something is classified as a security, the rules kick in: registration, disclosure, ongoing reporting requirements. Companies cannot just raise money from the public and disappear. There are obligations attached. Now that we know what a security is, the next big question is this: what happens before a company can actually sell those securities to the public? Section 3. The registration process. Before a company can sell securities to the general public, it must register those securities with the SEC. This is the heart of the 1933 Securities Act. Registration is not about the government approving your investment. It is about making sure potential investors have enough information to make an informed decision. The centerpiece of registration is a document called the prospectus. A prospectus is a detailed disclosure document that covers the company's business model, its financial statements, its risk factors, who runs it, and how the money raised will be used. This document must be made available to anyone thinking about buying the securities. When a company goes through this process for the very first time to offer shares to the public, it is called an initial public offering, or IPO. You have probably heard that term in the news. Going public through an IPO is a massive step for a company, and the registration process is one of the biggest reasons it takes so long and costs so much. Not every offering requires full registration, though. There are exemptions built into the law for smaller offerings, private placements, and intrastate offerings. These exemptions make it easier for small businesses to raise capital without drowning in paperwork, while still maintaining some investor protections. So what happens after the IPO? Does a company's obligation to investors just stop? Absolutely not, and that is where ongoing reporting requirements come in. Section 4. Ongoing disclosure and reporting. The Securities Exchange Act of 1934 is the law that governs what happens after securities are already trading in the market. Once a company is publicly traded, it must continue disclosing information on a regular basis. This is how markets stay fair over time. Public companies must file annual reports, called 10-K filings, with the SEC. These are comprehensive year-end financial reports that give investors a full picture of the company's health. There are also quarterly reports, called 10-Q filings, which provide updates every 3 months. And when something significant happens, like a merger, a change in leadership, or a major lawsuit, the company must file an 8-K, which is an immediate disclosure of that material event. All of these filings are available to the public through the SEC's EDGAR database. Anyone can look them up. This is the transparency that the entire system is built on. The idea is that when investors have access to accurate, timely information, markets can price securities fairly. But what happens when people try to cheat the system? What happens when insiders use information the public does not have to make trades that profit them at everyone else's expense? That is where securities fraud and insider trading laws come in, and the consequences are serious. Section 5. Securities fraud and insider trading. Securities fraud is broadly defined as any deceptive act in connection with the purchase or sale of a security, lying in a prospectus, manipulating stock prices, running a Ponzi scheme. These all qualify. The penalties can include civil fines, disgorgement of profits, and criminal charges that carry prison time. Insider trading is a specific and particularly serious form of securities fraud. It occurs when someone trades securities based on material, non-public information. Material means the information would matter to a reasonable investor. Non-public means the general investing public does not have access to it. Here is the key point. Liability does not stop with the insider who makes the trade. If that insider tips off a friend or family member who then trades on that information, the tipper and the tippee can both face liability. The courts have drawn a clear line. Using an information advantage that comes from a breach of fiduciary duty is illegal, period. Famous cases involving corporate executives and even celebrities have resulted in prison sentences and massive fines. The law is serious about this because insider trading corrodes public trust in the entire market. And that brings everything full circle. The reason all of this regulation exists is public trust. Without it, ordinary people would never feel safe investing their money, and capital markets would not function. Here is what you learned today. Securities regulation exists because of historical abuses that destroyed public wealth. The Howey test defines what counts as a security. Companies must register with the SEC and provide a prospectus before selling to the public. Public companies must continue filing reports after they go public. And fraud, including insider trading, carries serious civil and criminal consequences. If this helped you understand securities regulation, hit that like button right now. Subscribe so you do not miss the next chapter in this series. And drop a comment below with one question you still have about securities law. I read every single one. See you in the next video.